In this episode, we will be discussing California security deposit laws for collecting and returning. The California Civil Code, Chapter 2, Section 1950.5, governs the rights of landlords and tenants with regard to collecting, using, and refunding security deposits for residential rental agreements. Lawful use of security. Security means any payment, fee, deposit, or charge, except as provided in our video, California Tenant Application Screening Fee laws, that is imposed at the beginning of the tenancy to be used to reimburse the landlord for costs associated with processing a new tenant, or that is imposed as an advance payment of rent, or to be used for any purpose, including, but not limited to, any of the following: the compensation of a landlord for a tenant's default in the payment of rent, the repair of damages to the premises, exclusive of ordinary wear and tear caused by the tenant or by a guest or licensee of the tenant, the cleaning of the premises upon termination of the tenancy, necessary to return the unit to the same level of cleanliness it was in at the inception of the tenancy, or to remedy future defaults by the tenant in any obligation under the rental agreement to restore, replace, or return personal property or appurtenances exclusive of ordinary wear and tear, as long as the rental agreement allows for it. Maximum amount of security. A landlord may not demand or receive security, however denominated, in an amount or value in excess of an amount equal to 2 months' rent for unfurnished residential property and an amount equal to 3 months' rent in the case of furnished residential property. This is in addition to any rent for the first month paid on or before initial occupancy. It is important to note this does not prohibit an advance payment of 6 months' rent or more if the term of the lease is 6 months or longer. This also does not preclude a landlord and a tenant from entering into a mutual agreement for a specified fee or charge to make structural, decorative, furnishing, or other similar alterations, as long as the alterations are other than cleaning or repairing, for which the landlord may charge the previous tenant. Non-refundable security is prohibited. No lease or rental agreement may contain a provision characterizing any security as non-refundable. Security is protected from landlord creditors. Any security shall be held by the landlord for the tenant who is party to the lease or rental agreement. The claim of a tenant to the security shall be prior to the claim of any creditor of the landlord. Landlord claim against security. The landlord may claim of the security only those amounts as are reasonably necessary for the purposes specified in the earlier subsection, Lawful Use of Security. The landlord may not assert a claim for damages to the premises or any defective conditions that pre-existed the tenancy for ordinary wear and tear or the effects thereof occurring before or during tenancy, or for the cumulative effects of ordinary wear and tear occurring during any one or more tenancies. Tenant may request end-of-lease initial inspection of premises. Within a reasonable time after notification of either party's intention to terminate the tenancy, or before the end of the lease term, the landlord shall notify the tenant in writing of his or her option to request an initial inspection and right to be present. At a reasonable time, but no earlier than 2 weeks before the end of tenancy, the landlord or agent shall, upon the tenant's request, make an initial inspection prior to the final inspection that occurs after the tenant vacates. Purpose of the initial inspection. The purpose of the initial inspection shall be to allow the tenant an opportunity to remedy identified deficiencies in a manner consistent with the rights and obligations of the parties under the rental agreement in order to avoid deductions from the security. If an inspection is requested, the parties shall attempt to schedule the inspection at a mutually acceptable date and time. 48-hour advance written notice required for initial inspection. The landlord shall give at least 48 hours prior written notice of the date and time of the inspection if either a mutual time is agreed upon or if a mutually agreed time cannot be scheduled but the tenant still wishes an inspection. The tenant and landlord may agree to forego the 48-hour prior written notice by both signing a written waiver. The landlord shall proceed with the inspection whether the tenant is present or not, unless the tenant previously withdrew. It is important to note, advance written notice by the landlord shall also contain a paragraph required under California law regarding a tenant's right to reclaim abandoned property. You may visit AmericanLandlord.com to obtain this notice. Itemized statement of proposed deductions. Based on the inspection, the landlord shall give the tenant an itemized statement specifying repairs or cleanings that are proposed to be the basis of any deductions from the security the landlord intends to make. This statement shall also include the entire text of the earlier subsection, Lawful Use of Security, and then must be given to the tenant if the tenant is present for the inspection or left inside the premises. Tenant right to remedy deficiencies. The tenant shall have the opportunity during the period following the initial inspection until termination of the tenancy to remedy identified deficiencies in a manner consistent with the rights and obligations of the parties under the rental agreement in order to avoid deductions from the security. Deadline for returning security. No later than 21 calendar days after the tenant has vacated the premises, the landlord shall furnish the tenant, by personal delivery or by first-class mail, postage prepaid, a copy of an itemized statement indicating the basis for and the amount of any security received and the disposition of the security, and shall return any remaining portion of it to the tenant. After either the landlord or the tenant provides notice to terminate the tenancy, the landlord and tenant may mutually agree to have the landlord deposit any remaining portion of the security deposit electronically to a financial institution designated by the tenant. The landlord and the tenant may also agree to have the copy of the itemized statement along with the copies of documents showing charges sent to an email account provided by the tenant. Landlord to include documents showing charges. Along with the itemized statement, the landlord shall also include copies of documents showing charges incurred and deducted to repair or clean the premises as follows. If the landlord or landlord's employee did the work, the itemized statement shall reasonably describe the work performed and include the time spent and the reasonable hourly rate charged. If the landlord or landlord's employee did not do the work, the landlord shall provide a copy of the bill, invoice, or receipt supplied by the person or entity performing the work and include the name, address, and telephone number of the person or entity if the document does not include that information. If a deduction is made for materials or supplies, the landlord shall provide a copy of the bill, invoice, or receipt. If a particular material or supply item is purchased by the landlord on an ongoing basis, the landlord may provide a copy of a bill, invoice, receipt, vendor price list, or other vendor document that reasonably documents the cost of the item used in the repair or cleaning of the unit. If a repair cannot be completed in 21 days. If a repair to be done by the landlord cannot reasonably be completed within 21 calendar days after the tenant has vacated the premises, or if the documents from a person or entity providing services, materials, or supplies are not in the landlord's possession within 21 calendar days, the landlord may deduct the amount of a good faith estimate of the charges that will be incurred and provide that estimate with the itemized statement. If the reason for the good faith estimate is because the documents from a person or entity providing services, materials, or supplies are not in the landlord's possession, the itemized statement shall include the name, address, and telephone number of the person or entity. Within 14 calendar days of completing the repair or receiving the documentation, the landlord shall then complete the requirements for returning security and providing any documents showing charges. Exception to having to show documents. The landlord need not comply with having to show documents of charges if either of the following applies. The deductions for repairs and cleaning do not exceed $125. Or the tenant waived his or her rights specified in the subsections landlord to include documents showing charges, and if a repair cannot be completed in 21 days. The waiver shall only be effective if it is signed by the tenant at the same time or after a notice to terminate a tenancy has been given or a notice to quit. The waiver shall also substantially include the text of the subsection, landlord to include documents showing charges. Tenant may request to see documentation of charges. Notwithstanding the subsection exception to having to show documents, a tenant may request for documentation of charges within 14 calendar days after receiving the itemized statement. The landlord shall then comply within 14 calendar days after receiving the request from the tenant. Penalty for landlord non-compliance. The bad faith claim or retention by a landlord or the landlord's successors in interest of the security or any portion thereof in violation of this section, or the bad faith demand of replacement security, may subject the landlord or the landlord's successors in interest to statutory damages of up to 2 times the amount of the security in addition to actual damages. It is important to note the requirements of this section do not apply when the tenancy is terminated for non-default of rent reasons pursuant to the laws covered in our other video, California Landlord Reasons for Eviction of Tenant. For additional laws and articles, visit AmericanLandlord.com.